welcome to ME-Arcone Queing, a podcast initiated by the Institute for Alternate Dispute Resolution, New Delhi. This is a brand new series, and if you're tuning in for the very first time, you're exactly where you need to be. Here, we explore how conflicts can be resolved smarter through mediation, arbitration, negotiation, and conciliation. People centered approaches that save time, reduce cost, and preserve relationships. Because courts across the world are overburdened and many disputes, interpersonal, commercial, everyday can be resolved far more effectively outside the courtroom. ADR empowers parties, encourages dialogue, and allows the judiciary to focus on cases that truly demand adjudication. This podcast is built for every aspiring lawyer who has ever wondered what is ADR, where do I begin, and how does it actually work? We'll be bringing you real conversation, real insights, and no fluff. If you enjoy what we are building here, like, comment, and share. This space grows because of you, and if you know someone curious about arbitration, mediation, or the mind shaping the ADR landscape, share this episode with them. Let's keep the conversation expanding because ADR isn't about settling disputes, it's about rethinking how justice works. This is ME-Arcone Queing, and this is just the beginning. My name is Kavika Sharma, a fifth year law student and an intern at the Institute of Alternate Dispute Resolution. It is a pleasure to be your host for today's episode. And today, joining us is someone who brings with him nearly 4.5 decades of legal experience across some of the most dynamic areas of law criminal, labor, corporate, banking, insolvency, and electricity law. Our guest, Mr. Anil Kumar Chaturvedi, is currently empanelled as an arbitrator with the Indian International Arbitration Centre and the Delhi International Arbitration Centre at the High Court of Delhi. Beyond practice, he serves as guest faculty at IIM Bodh Gaya and as a professor of practice at Maharaja Agar Singh Institute of Technology and Management, Delhi. Shaping the next generation of legal minds, his career spans remarkable roles from presiding officer at the Debt Recovery Tribunal to serving as the chief legal officer with the erstwhile Delhi Vidyut Board, where he played a pivotal role in one of Delhi's most significant infrastructure reforms, the successful privatization of cities' powerful distribution, giving rise to NDPL, BSES Yamuna, and BSES Rajdhani between 1998 and 2003. He has also served the Ministry of Corporate Affairs as official liquidator, registrar of companies, and regional director, a career that is, in every sense, extraordinary. We are truly honored to have him on ME-Arcone Queing. Welcome to the show, Mr. Chaturvedi. Sir, before we begin, let me just set the stage for our audience. We have called this episode the Quiet Revolution, and the reason is simple. ADR hasn't come with loud announcements or big headlines, but slowly, steadily, it has changed the way disputes are resolved in this country. From corporate boardrooms to labor, from banking conflicts to electricity reforms, ADR has been working quietly in the background, solving real problems for real people. And that, we believe, is a revolution worth talking about. You have seen this transformation from inside, sir, across 44 years of practice across multiple areas of law, and now as an arbitrator at two of India's most respected arbitration centers. So we couldn't think of a better person to have this conversation with. Let's begin. Sir, you have been practicing law for over 44 years now. That is an incredible journey. So let's start from there. In all these years, when did you first realize that ADR was not just an option on the side, but something that was truly needed? Was there a moment, a case, or an experience that made you think that this is the future?
Vika, I joined legal profession in 1981-82. Frankly speaking, when I did the law and when I came out of the university area, we were never taught what is the courtroom, where are those, what is our requirement, how to appear before the court, how to address. There were no one to guide us. You are in the era where lot of facilities are now available, online, offline, So many forums have been created. In our time, there were only traditional courts were there. One court was district court, and below that Mufassil court, above then High Court and Supreme Court. And Supreme Court and High Courts were of our dream. If one day we will go and appear, because no one has godfather in legal fraternity. What I realize is in last few years, even I can very well say youngsters have very struggling time today. In Delhi itself, before 4 years, if you look into the Bar Council registration, there were 69,000 advocates were registered. 69,000. When I joined, that time less than 5,000. Now, in last 4 years, it has gone up to 1,70,000 in Delhi itself. In total, our country, we have 1.5 million advocates. 1.5 million advocate. And if you look into the judges number, traditional court, if I talk, the but last data I have seen, 21,000 judicial officers, right from Mufassil Court to Supreme Court. Now they have gradually increased the number. One problem is there are huge vacancies. 30% vacancies are lying, whether it is a district court, high court level. Of course, Supreme Court, they have started now beginning. They have full strength. Recently, it has been increased to 38 from 34, inclusive of Chief Justice. So, what I say, there were no legal intern word in my time. We were not knowing what is legal intern. So, when I joined the profession, we were searching some good advocate at district court level who can guide us. Could you believe it? We were not knowing even, and we were never taught chapter LLB to get enrolled our, you can say, you can blame our system. So one my professor asked, you have, because we were not doing advocate work, we were simply LLB, and we thought after LLB we can go anywhere. Then he said, no, you can't do like this. You have to get registered yourself. Luckily, he was secretary to the Bar Council of Uttar Pradesh. He got me enrolled. So what I say, youngsters today have difficult time. Again, coming to the main. So what I realize is in my time, there were no alternate dispute resolution mechanism, except in petty criminal offences or in civil cases. If party agrees, then compoundable word was used in the criminal law, and in civil, compromise. This is the difference. One is compoundable, one is compromise. So, which was part of CPC also and our CRPC also. What offences are compoundable, what are not compoundable. So thereafter, what happened in 1974 in Gujarat, some person have approached to the, somebody had challenged, and the Supreme Court matter came up. What were happening in tribal area? They were settling murder cases and attempt to murder cases, which was not allowed by the our judicial system. So ultimately, Supreme Court says, no, this way you can't do. You have compromised or compounded your offense of heinous offenses, which is treated as against the society. Against the society. So there are two kind of offense in criminal law. One is called right in rem, right in persona. In persona case, you can compound. Depending upon guideline of the CRPC again. In my time, up to 250 rupees of if theft is amount of 250, you can settle. There was no bar. But what I am trying to say, there was no where word used alternate dispute resolution mechanism. So now you are asking me how it has come. So law commission was set up because at that time around 1.5 crore cases were pending in the court.
Mm-hmm.
Then, and there were many persons who were not able to approach the court. See the irony. So we have created now, after Legal Services Authorities Act 1987, we have created District Legal Aid Committee and High Court level legal committee and Supreme Court level. But even now, after constitution of these fora to assist the poor people, they are not able to use it because, and quality of advocates is also not good. No good counsel want to contribute. Youngsters want, but they also come and go, just like a bird comes and fly. After getting few cases and experience, they decide. So it is a very noble cause. So this was the situation. So what I decided, I was junior to late Ram Jethmalani sir.
Okay.
I was junior to him for 6 months around. He was very kind. He was helping young lawyers to guide them. He was not charging any money. Rather, he was paying out of his pocket, paying to juniors.
Oh.
I'm talking about 1982 time.
Mm-hmm.
Nowadays, what is happening with the seniors? Either they are interested in their kith and kin. First preference is given to their kith and kin. I am the first generation lawyer and last also. My daughter and son both have decided not to join.
Mm-hmm.
They say it is your cake, not of theirs. And they rather dislike our wearing black coat and other things. They say, what is your job? We don't know. Because we have created image in the eyes of investors. If a person goes to court, he has been dragged for centuries, decades at least. You see, suppose a employer cheated the employee not paying wages. If he go to court of law, it takes decades to decide his case.
Mm-hmm.
Same way, if somebody cheated on the property, if you go to civil court, because we have very ladder system in our legal system. First, you have to go trial court. Like in Delhi, the Delhi High Court has original jurisdiction also. So in
Yes.
Ghaziabad and other places, you will not find, because our courts are creation of High Court Act, and
So,
Britishers have created by British Parliament three major High Court:
mm-hmm.
Kolkata, now is it sorry, Calcutta, Madras, and Bombay High Court. These were creation of their legal system by British Act. That's why they are not able to change the name even. The city's name has been changed.
Mm-hmm.
Rest high courts have come thereafter. Some pre-independence, Allahabad High Court, like other High Court, Patna, and some came after independence. Nowadays, we have 25 High Courts in our country. 25 High Courts across the country, because we have 28 states and 8 union territories. Some high courts are common for various union territories or small states. That's why numbers is 25. Looks very lucrative. But again, I am saying, what is the approach in our legal system? If some person comes, like you are doing, you are about to pass the law, you
Yes,
told
sir.
me final year.
Yes.
So after that, you must have decided by now what you will do after passing out, because you
Yes.
have to plan
Mm-hmm.
at least for 5 years next or 10 years next.
Mm-hmm.
If you are choosing this legal this profession, in my time, I said, as I said in the beginning, there were no guide.
Mm-hmm.
No person was there to guide us except those who are having their father advocate or brother advocate. They have joined the profession, their offices. They were helping. But for a person like me, no one was there. Then I decided to join the through UPSC and Public Service Commission, I came
mm,
to
mm,
this government side. So 5 years I tried my luck as an advocate,
mm.
but I sincerely believe even in those days I was trying to get poor people cases at my own without having any money. What
Mm,
was my source of income? You will not believe it. You know, oath commissioners are notified by district judge at district judge level, and in
yes.
high court also high court level. Yes,
Mm,
you have to opt for a oath commissioner, and normally they give you 2 years empanelment as an oath commissioner. That is my first suggestion to youngsters. Those who want to join the legal profession, they must opt for oath commissioner.
okay.
Why I am saying so? There, but you have to perform sincerely.
Mm,
Because in my time also, when I was notified as an oath commissioner for 2 years, I was there. Many advocates were not coming even to, because there is a every district and high court you will find oath commissioner pool of oath commissioners. There is
mm,
a one clerk appointed by those oath commissioner itself or bar.
mm,
And in my time, per affidavit it was 2 rupees.
mm,
For 2 rupees we were giving attestation, but they were doing mechanically. But
mm,
I decided I was reading affidavit contents, pointing out mistakes, and insisting the physical presence of the deponent. I never compromise.
mm,
And I can very well say, my time, Air Vice Marshal, who was having some family dispute
mm,
over his mother property, he, I forced him to come to Oath Commissioner pool. So his subordinate officer came, sir, we will take you by vehicle, we will get you back. I said, no, I will not go. And I
mm,
told that clerk also, you will also not go.
mm,
And I was sitting from 10 to 5. 10 to 4 is the time.
mhm,
And I was having maximum attestation.
mm,
Though there was a sharing of revenue system, you can say.
mm,
2 rupees per affidavit they were collecting. And at the end of month, it was distributed among all oath commissioners, irrespective whether they were there or not there, or whether they attested a single affidavit or not. This was the system.
mm,
One can have a grudge if somebody is not coming, why he should be paid. But
mm,
there was no question of fighting from my side. I am telling you truth.
mm,
What is the reality of the life?
mm,
Sir, that's a separate issue. Let us come to the topic. So ADR system came after this law commission recommended, and this Legal Services Authorities Act 1987 was enacted. This was the first legal reform in which Lok Adalat were constituted for district level, high court level,
mm,
you can say state level, and Supreme Court national level, NALSA.
mm,
And normally in those fora, the next second number senior judge was having, he was ex officio president of the Lok Adalat at district level, and in High Court, also second number judge was having Legal Services Authorities Act, those High Court, this fora. And same way in Supreme Court,
mm,
NALSA. But what was happening, ADJ and others, like in district level, Chief Judicial Magistrate, now we called, earlier Chief Metropolitan Magistrate. He was the member secretary of the those legal committee.
mm,
So how this legal services authorities had conceptualized that let us have Lok Adalat for settlement of the, it was for pre-litigation stage and
mm,
post also,
mm,
and with the consent of both parties. And in criminal, minor compoundable offense were also included for Lok Adalat.
yes,
This was the one.
since we are talking about criminal laws, and
Yeah,
you have worked across so many areas of laws, that is criminal, labor,
correct, correct.
corporate, banking, insolvency.
I'm
Each
coming to
area
that. Yeah.
has,
Sorry, yes, yes.
each area has its
Please.
own kind of disputes. So, how do you know when to go to court, when ADR is better choice? From your experience, How should a
Correct,
beginner
correct.
start developing that sense of judgment?
I suggest youngsters today, as I said, one job that in the beginning itself you can undertake, join some legal services authorities, this advocate, this empanelment. If you really have work hard, you will get reputation also to help poor litigator. You will get cases also because there is a acute shortage of good advocate. I am telling you. Those
Yeah.
who don't believe in working hard, I am not blaming anyone individually,
Mm.
but it is the common feeling of litigant
Mm.
because they need those who are behind the bars.
Mm.
You know, in one case, Supreme Court in my time, 74 or 80s, I am talking,
Mm.
was behind the bar for the total this punishment prescribed in the our statute was more than it. Then
Oh.
Supreme Court framed the guideline to take out all those cases where 10-year or more, 10-year or lesser offenses people are behind the bar without facing full trial, and they were directed to release on bail or personal bond even. This has also curtailed, but ultimately problem is timely disposal is not there. Today we have 5.5 crore cases.
Yes.
In the right beginning from district level, we have around say 4 crores.
Mm.
If you talk 40 millions,
Mm.
and in the High Court level 60
Mm.
lakhs, and in Supreme Court we have around 90,000 cases pending today.
Mm.
This is the irony. Another area youngsters can opt for advocate on record. Normally it is required, but there you need in my time it was 7 years experience required for entering into that eligibility test or exam.
Mm.
Every I think 6 months they were holding those exams, but now it has reduced to 4 years. It
Mm.
means till next 4 years when you pass out, you cannot become advocate on record.
Mm.
The 4 years what to do? So you have many area of expertise. One, as I said, you get panel of legal services authorities
Mm.
because there you will get automatic cases.
Mm.
Member secretary will offer you many opportunity,
Mm.
but only thing you have to survive at your own. They give very lesser pecuniary attraction. This is one area I'm telling you.
Mm.
And many advocates, those who are passing out for 5 year course or more, and they are because they have some have borrowed money also education loan, some because everybody is not rich. Now education itself is very costly affair. If
Mm.
I rightly I have said, will say around 20 lakhs people are spending to learn the law,
Mm.
4 year 5 year course,
Yes. Mm.
20 lakhs. They
Mm.
are too at a very conservative manner.
Mm.
Those who believe in luxury, they have to spend more also
What?
because
Yeah.
many people are going abroad also. Many
Mm.
people, but what is the problem? Doing law from abroad is not a problem,
Mm.
but you can't practice in our country. Our law in any country other. If you go there, you have to pass their exam of
Mm.
their local laws. Same thing is happening in India also. So I
That,
don't believe. Sorry.
no, that is actually
If
a
you
perspective that our viewers can take
yes
home. And
yes.
mm.
Suppose you have to go to abroad for studying. That I suggest first you gain the experience here, three,
Mm.
4 years, then you go abroad. Then you
Yes.
will able to qualify those exams also in like in UK or in New York. Some of my known persons have qualified there
Mm-hmm.
and they have started practicing there.
Mm.
But their legal system is totally based upon chamber practice.
Mm.
They have bar at law system. We have advocate system. Nowadays, how many bar at law you will find? No, very negligible. Except in Bombay, you will find some, and Kolkata are majority because those people goes to study law in UK. Mostly people go London. for studying law. Oxford or somewhere they are studying. Let us come to what I say. So you should join this club, legal services like provide fora, and then another fora is provided by the like oath commissioner. I said attestation.
Yes.
What you will learn from there? Many affidavits come prepared by advocate, experienced advocate also. So
Hmm.
don't attest in a minutes. You read those affidavits. If you find there are good quality affidavit, you can have copy of that. That will help is to develop your skill also. How
That
to
is
how
actually
to draft the affidavit. Yes,
hmm. Yes.
because in college and university we were told only very few cases we prepared affidavit or pleadings. Because
Certainly, that is
their
not
aim
something
was
we
to
at law schools. We don't get to learn
yeah,
that at law schools these days.
yeah,
Certainly, sir. Speaking of which, you were a part of something truly historic, like the privatization of Delhi's electricity distribution.
correct, correct,
Gave birth to NDPL, VSCS Yamuna, and
correct, correct.
VSCS Rani. That was massive. Um, there must have been enormous conflict along the way. How are those disputes handled, and what can today's area students and practitioners learn from an experience like that?
Correct. See, I joined Delhi Vidyut Board as it was earlier.
Hmm.
Nowadays it is because it is a dissolved body. Only we have Delhi Power Company as a mother company,
Hmm.
holding company you can say.
Hmm.
These remaining five companies are subsidiary of those companies.
Hmm.
So those are named as BSES, Rajdhani, Yamuna, and NDPL. One is in the first generation company, in the first power generating company, and one is this Transco, Delhi Transco Limited, for transmission line. See, in electricity, what is the process? First, electricity is generated, uh,
Hmm.
for which in Delhi we have very less power generating
Power.
space,
Hmm.
and for Rajghat and other power stations were declared because of pollution anti because of MC Mehta case, those were closed now. You
Hmm.
will not find one only Pragati is there. It
Hmm.
was commenced in my time only.
Okay.
In early 2000, it was 330 megawatt power generating unit.
Hmm.
So it is based upon gas based because
Okay.
earlier we were having generated through coal
Hmm.
or some oil.
Hmm.
Like NTPC is generating in Dadri.
Hmm.
So today, in that time, we were depending upon power source
Hmm.
outside Delhi.
Hmm.
So, and what was happening? We were not having proper transmission line,
Hmm.
and many times there is a grid system in power.
Hmm.
Uh, I'm just in 2 minutes. I will explain you.
Hmm.
So there is a national grid:
Hmm.
northern, southern, eastern, western. So most of the those heavy power stations were part of outside Delhi. Then power generated. So how it will reach to Delhi or other places, other states? So one transmission company was established by Government of India, Power Grid Corporation of which has registered office in Nehru Place.
Hmm.
So because states were not sufficient to provide money for establishing transmission line. So central government has taken undertaken this job.
Hmm.
So if you heard about erstwhile Electricity Supply Act 1948,
Hmm.
which is now everything is merged with the new Electricity Act 2003, right? So what was happening earlier? There were two acts: Indian Electricity Act 1910, because when electricity came to India, 1901, first time.
Hmm.
Before that, there was no electricity.
Acha.
There
Hmm.
were generators small.
Hmm.
Some Viceroy or Governor General who came to India, so they were feeling very hot climate. So they bring themselves a small generator run on kerosene from their country, UK or some. That time no flight were there. So in ship they bring those things and they establish at their bungalows. So many of Indians were not seen electricity. What is that? Because electricity is an innovation of 19th century only. Before that, nowhere there was electricity. If you heard about Sir Alexander Fleming and Thomas Alva Edison,
Yes, sir.
those have invented bulb, electricity bulb, and one has created how electricity can be generated and transmitted. So anyhow, can cut it short. So the transmission company was established. Then question came, power generating, no state was capable to establish power generating units in their state. So Central has established one National Thermal Power Corporation and one National Hydropower Corporation, NHPC. And another was came nuclear power company, which has few places like in Madras, some Palakkal or some spaces there, and name forgotten. In Tamil Nadu, you will find, in Mumbai, you will find Trombe, and in UP, there is a Narora, this Bulandshahr area. There you will find. So we have four sources of power generation: one thermal power, one hydropower, one nuclear power. And now, recently, this government has added solar energy also because they are focusing on renewable energy. So after 10-20 years, you will find that there are no coal-based thermal stations in our country or oil-based also, because oil is also going to be uh, gradually finished. So we have to depend upon alternative source of energy. That's a separate issue. So what I say, so in my time, Delhi Vidyut Board was incurring losses in and many states also. So there were one state, Odisha, you heard. Odisha was the first state in under the leadership of Naveen Patnaik. They introduced electricity reform. So they made, but they made company only thereafter, because there is a lot of resistance from engineers and staff. They don't want privatization. So in Delhi, we introduced the Electricity Reform Act 2000, which earlier it was ordinance, then converted into act in 2002,
Okay.
under which this company concept has came. And we have not sell anything to these companies. We have transferred the business of distribution to these companies. They, and 7 years they have been given that what you say moratorium in law,
Okay.
because they were given zero balance sheet, plus they have been given for 7 years to reduce their losses, make it to 10-12% only. Till then, the government has provided subsidy through our Transco company. This was the concept of privatization.
That is actually the kind
So,
of that comes with
mm,
experience.
yes.
So,
So nowadays you must have seen that you are getting better electricity than DBB times.
yes.
When I joined, it revenue was around 100 crores only per month, and wages bill was more than 80 crores. So whatever money was coming, we were not able to pay power purchase this to NTPC or NHPC. And when I did this privatization, 30,000 crores were losses. Who will come for accept privatization? So that money is still not paid. I am telling you, the government has freezes that amount. Yes, and we were given subsidy. So we made first make with the company, holding company and subsidiary, and then we what we called a shell company. Because initially it was not privatized. So we made shell company. So my registrar of companies was not agreeable. Bole, what is shell company? You are going to commit fraud. मैंने कहा no. unless and because we were converting sovereign into company.
Hmm.
Sovereign you cannot privatize.
Hmm.
State is a sovereign.
Sovereign.
So we transferred each state asset in the name of LG and three, four secretaries.
Hmm.
So LG is the custodian of all immovable, movable assets of these companies.
Hmm.
They have been given to use it,
Hmm.
and people made a false claim in the newspaper, etc., that state has sold for 1 rupee. No, it is a lease amount, because otherwise he will hold permanent lease. For 30 years, license has been provided to these companies for
Hmm.
distribution, and they cannot change their name also for
Hmm.
30 years. That's why the BSES is now held by Adani Group, not by Reliance, but they are still using BSES name. And NDPL is Tata. It was the first venture on behalf of Tata to have this privatized distribution. They were not agreeable, but we have given them so that competition should be there for future.
Hmm.
Otherwise, monopoly will ally
Hmm.
anyway. So this is the one way.
Hmm. Sir, your work
Yeah.
highlights how mediation within the judiciary can reshape not only how disputes are resolved, but how justice is experienced. We are truly
So,
grateful for your time, sir. Yes, sir.
so I am coming to your point.
Hmm.
We are our topic is alternate dispute resolution.
Yes.
So when I joined, electricity board DBB was having 50,000 cases in High Court,
Hmm.
and again hundreds of thousand cases in district level court.
Hmm.
You can imagine when I joined there, I
Hmm.
was surprised how to control this litigation,
Hmm.
because we have been taken on deputation
Hmm.
to reduce that pendency.
Okay.
So in my time, there was a one case came.
Hmm.
I'm taking your time. Power crisis in Ames.
Hmm.
It is a famous case. You can note down the citation for your future help.
Hmm.
Uh, so how it has happened? Power crisis in Ames.
Hmm.
You
Okay.
will say, yeah, how Ames is concerned with the power crisis.
Hmm.
Former Justice of Supreme Court mother was admitted to Ames for some
Okay.
surgery. He was given, she was given anesthesia.
Hmm.
He was there in this May, June, it has happened, this June month only.
Hmm.
So what happened that time, Ames was having only one transmission transformer of 66 kV.
Hmm.
When she was given anesthesia, all of a sudden supply fails,
Hmm.
maybe because of overload or something.
Hmm.
And her mother took around 6 to 7 hours to regain conscious without operation. So you
Oh.
can see the mental agony in the mind of the honorable judge.
Hmm.
So next day he was sitting in the summer in the court. So he mentioned that matter. Then Times of India published the news at front. Power
Oh.
crisis in Ames. So because the Supreme Court after Justice P.N. Bhagwati case of
Hmm.
Asiad Village,
Hmm.
where stones laborers were subject matter of cruelty or harassment by employer. So he converted first this public interest litigation in the form of taking cognizance on the basis of a postcard.
Hmm.
Somebody written postcard to Chief Justice, and it was converted into PIL.
Hmm.
Not like today. Today it is I called sometime. Electricity Reform Act came. Then we uh, go for privatization,
Okay.
because in power crisis case our main thrust was before Supreme Court. We were summoned, as I said, in we were not knowing. I was totally new that time in electricity board.
Hmm.
My chairman called me कि some newspaper published some story before my joining. You look into that, what is that? Then I visited Supreme Court. Then Supreme Court registry people helped me. Bole, this is the PIL under the title of MC Mehta case. There is a famous one case which is running for decades, even
Hmm.
Supreme Court. Even today, it is not disposed of.
Yes.
Every public interest litigation, someone can file IA. if it is matter of public importance. So under that, they converted into PIL. And IA system you must be knowing, or you may be knowing thereafter. I will guide you what is IA. So interim application, the word is used, interim application. So in Supreme Court, we were summoned, notices were issued. So then by the time in High Court also started, same problem with the power crisis in Delhi. They use the word power crisis in name. Then I said, ki Honorable Supreme Court is also hearing, you are also hearing. So what my chairman was worried, ki what stand we should take. There should not be any conflict. Because their topic was concerning power failure in aims only. Here it was concerning whole NCT of Delhi, National Capital Territory of Delhi. So anyhow, so I made a statement. So I filed affidavit, and our counsel was now retired Justice Jayantnath was our standing counsel. So we filed affidavit reply that because of rampant power theft in Delhi. In East Delhi, if you know the word, East Delhi we called across Yamuna. So there was a theft of 80 to 90% power thefts were there. You can imagine. 90% roughly was power theft. Because all were unauthorized or irregular connections were there. Before that, what happened in Delhi when electricity was came in 1910, first time. So because it was a rare commodity that time. So under Indian Electricity Act, this 1910, so post independence they made, we called draconian law, Delhi Electricity Control Order. It was framed under that act. Under the MCD, we were part of 1957 Delhi. It was part of one of the services, power utility services. So there was a clause in the Rule 4 that no one can be granted connection of more than 2 kilowatt. 2 kilowatt, I am using the word. And maximum connections, even now today, if you visit, I don't know whether now they must have increased. Why fire occurs? Because of sanction load is there. Sanction load, what is that? For which you have contract with the electricity supply company. At the time of initial grant, they were having 0.25 kilowatt connection. 0.25 I am using. In all commercial connection, you will find like that. And line is not as per that. Supply line has to be strengthened. And people are having so many air conditioners and many gadgets are coming, light and so many things. Earlier days, lights were not there. So they were selling their goods under the daylight only. Now, so many neon signs, everything is coming. And geyser, what I am saying is many gadgets have come. But no one has ever paid heed. They should get increased power load also. So in 99, I was summoned by Chief Justice Court of Delhi High Court. So they say, why you are not granting connection? And we will summon your Chief Secretary. I said, by summoning Chief Secretary is not going to solve this problem. Why? If you really want permanent solution, why suggest it there orally? Instead of calling under Delhi Electricity Control Order 1959, there is a limit of 2 kilowatt only. So I say, if this court has power under writ jurisdiction, you direct the state government to make amendment in the rule. 4A should be added, not 2 kilowatt, as much as he required. Then this problem will be solved forever, because electricity companies are buying electricity as per sanction load only. Suppose in your house or in your office, today you have suppose 2 kilowatt connection only. I am just using the word for example, not yours personal or this your office. So electricity company will supply you as per in their record 2 kilowatt. Suppose you increase your load, you have so many ACs like or some other gadgets are there. So what will happen? Line will have interruption because electricity is a commodity which you cannot store. Your gadgets will stress the electricity. Then ultimately fire may come, fire may happen. So that's why it is suggested to everyone to get power audit every 6 months at their house level and industrial level or office level. Why it is so? That technician will guide you how much load you should get sanctioned. But our nature is to save the money because we have to. Electricity department is a commercial department. So whatever load you will ask, they will provide you per kilowatt. They will charge you because line has to be dragged from main source to your house or your office or your shop. So this required expenditure. Electricity department don't have such a revenue, so they get money from customer users. You have to pay for that.
Okay.
Then electricity engineer will drag the line and he will install proper these safeguards. Then you will not face any fire at your house or your shop. This is my all advice to all sincere users. Recently, you have heard Malvi Nagar, what happened? Unauthorized. It means he was not having sanction load even. We don't know how much load he was having. And because of malpractices of AC and others, that fire occurred from basement. We don't know exact reason. The matter is under investigation. So in summer we face, in winter also we face, because that time we uses the heater and room warming and geysers. So our uses are like this. So in cut it short, so we suggested that there should be 4 special court for having day-to-day basis power theft cases criminal trial.
Okay.
Delhi High Court sanctioned me. We provided the infrastructure. State government transferred the budget for this because the judiciary cannot accept salary from PSU. So that thing I learned. So we requested Delhi government to provide funds to Chief Justice High Court so that they get the salary. And you will know first who was the Metropolitan Magistrate Special. President Justice Sonakanta Mehra that time she was. She was our first Metropolitan Magistrate in Sakti Southern ITO. Building is still there. So there we established 2 courts there, 2 Metropolitan. And thereafter what happened, I was also dragged every day in the High Court and district courts. So many cases were pending for, say, those who were objecting to electricity bills, they were challenging. So I was summoned by, in one of the case in 99, but actually it happened in 98. So in the court of the then Justice Anil Dev Singh, who later on become Chief Justice of Rajasthan High Court. So I appeared before him and I suggested that by summoning chairman and other members, this problem will never solve. So I suggested them, well, then what to do? So I read one article. That time, Dr. A.S. Anand, who later on became Chief Justice of Supreme Court,
Okay.
he wrote one article in the Nalsa. What was the subject? He conceptualized permanent Lok Adalat. Instead of having Lok Adalat periodically, like every 3 months, for power utilities or utilities services, he suggested if we have day-to-day basis working day court 10 to 5, then we can reduce the pendency. And I suggested that article before the Honorable Justice, and he has agreed. Though my councils all have opposes that time. Standing council says how you can make a statement without you are advisor to board. But I made a statement, but I conveyed to board. Board has agreed to my suggestion, and then we developed the permanent Lok Adalat near Mata Sundari College in near ITO.
Speaking of which,
If you will find,
yes,
yes,
sir, you are currently
that time.
Hanji.
So 2 Lok Adalats permanent, and it was inaugurated by the then Chief Justice, and 8 more judges came to inaugurate the same building because it was that's why I earned the goodwill from the court,
Hmm.
because I tried. And in those lok adalats, I am telling you, permanent,
Hmm.
50,000 cases were reduced into 4,000 in
Oh.
6 months' time. And how much revenue we generated? 975 crores, which was locked up in litigation. I have not done miracle. What I did, I say we should try to recover principal amount first.
Hmm.
And for interest part, I say board should grant 50% concession by amnesty scheme. And 50% we leave it to the permanent lok adalat to reduce. Otherwise, who will come to the court?
Hmm.
So that's how we reduce. And because companies were insisting they want without litigation privatization. They say we will not take up your cases.
Hmm.
So that was the difficulty. Anyhow, everything happened. And currently, thereafter Electricity Reform Act came. I was called by late Arun Jaitley sir.
Hmm.
He said, how you can make permanent lok adalat without having provisions under Legal Services Authorities Act?
Hmm.
He was right. Then I said, I did through writ petition.
Hmm.
So thereafter, Section A was added. So now you will find in 2002 amendment in
Hmm.
Legal Services Authorities Act, which is the outcome of a judgment. Again, I am giving you citation. Abdul Hassan versus DBB, AIR 1999,
Hmm.
page 99.
Okay. Hmm.
So this was the case, landmark judgment for creation of permanent lok adalat in India at all India level for all public this utilities services. Permanent lok adalats were created. 70 government of India departments like telecom, electricity, municipal corporation, property tax matter, all these things have been subject matter of this. So this is called alternate dispute resolution mechanism.
Hmm.
Without having statute. In 2002, statutes came. Then,
Hmm.
meanwhile, what happened in court pendency? Earlier, we were having Arbitration Act,
Hmm.
Indian Arbitration Act 1940.
Hmm.
Before that, Britishers have framed.
Hmm.
They were commercial people.
Hmm.
So in 1889,
Hmm.
they created one mediation process.
Hmm.
You will nobody reads this history.
Hmm.
So that time alternate dispute resolution mechanism was for income tax purposes.
Okay.
Income tax appellate tribunal came in 1941.
Hmm.
Before that there was no such process.
Hmm.
And in 96 a active enactment was made, Arbitration Conciliation Act
Hmm.
1996,
Hmm.
which has brought first time in the history of India.
Hmm.
One is arbitration, another is mediation, and third is conciliation.
Hmm.
So these are alternate source of
That is
what
that.
happened. But arbitration, many people like arbitrators was having right to fix up their fee. So many people cried. Then this government in 2016 amendments were carried out, and in 2019 also another amendment under Arbitration Conciliation Act. What amendment that? Arbitrator fees has been fixed in the schedule.
Hmm.
Now, under the schedule, as per value of the dispute, their fees are fixed. Whether he takes 5 hearings, 10 hearings, it is for arbitrator to see that. Why it has been made? In within 12 months, he has to dispose of arbitration. Arbitration is a basically private negotiation. Private. It is not a litigation. Actually, privately in this negotiation
Negotiation.
between two parties.
Hmm.
Arbitrator is the judge who decides.
Hmm.
How it happened? That first arbitrator is appointed. Many controversy arise कि arbitrator having bias.
Hmm.
After arbitration award is allowed, then many people go to court, Supreme Court. Then Supreme Court fix up the one judgment, and one section 12 was introduced.
Hmm.
Section 12 we will find every arbitrator has to give independence
Independence. Yes.
declaration.
Hmm.
That is mandatory now.
Hmm.
Thereafter, arbitration matter is placed before him.
Yes.
And thereafter, no party can raise this objection before court that arbitrator has bias. Unless until on documents he proved that if this arbitrator has given false statement or declaration. Right?
Yes. Right.
Then, and fees has been fixed up. So, but what is happening? Again, equal distribution of arbitration matters are not there.
Hmm.
Still, courts and parties are preferring retired judges only.
Hmm.
You are asking for career of arbitration at young level.
Hmm.
So as of date today, what is the qualification for becoming arbitrator is 10-year experience
Hmm.
dealing with commercial and civil dispute.
Hmm.
Then one are eligible to become arbitrator also.
Okay.
But normally, like DIAC and other institutions which are also created after this 2019,
Hmm.
because government wanted institutions should be developed
Hmm.
to deal with the arbitration matter.
Hmm.
So this DIAC has been created in some more High Court, Andhra and other also places. These centers are there, which is headed by retired impaneled judges are retired and administered and facilitated, you can say, by one of the senior district judge level who called coordinator. Coordinator. Suppose you want trainee in the DIAC.
Hmm.
So very simple process is there. You have to apply online or any youngsters who want to, but in final stage, not
Hmm.
first year, second year, because that may not be helpful for him also.
Hmm.
So suppose somebody is in the final year, he or she can apply online
Hmm.
website of the DIAC
Hmm.
for and upload the documents,
Hmm.
and 2 months before of the desirous period of training or internship. So there is no fees for it, no fees, no professional fees.
Hmm.
You have to simply apply. Like I have been impaneled as an arbitrator, I need not to pay any amount.
Okay.
I have simply applied for High Court of Delhi,
Hmm.
and there is a full court system. They
Hmm.
scrutinize our resume or profile, and in the full court, they recommend to the Chief Justice of Honorable High Court, who once he approved the panel, then for 5 years they are impaneled. After 5 years, they have to again apply, and 75 is the upper age limit for becoming arbitrator. I
Okay.
think quite, 75 is a good,
Good.
I
Hmm.
think, good length of service. Youngsters should also come.
Hmm.
And India International Centre of Arbitration, IICA, I
Hmm.
was member there. I am member for next 5 years there also.
Okay.
There, if you want to empanelment,
Hmm.
one has to apply along with 10,000 fee for the domestic arbitrator panel and 20,000 for international arbitration panel.
Okay.
These are the fees fixed under the Act or Schedule, you can say, under Arbitration Act amendment scheme. No, so their fees has been provided for by the institution itself.
Hmm.
DIAC has not having any fees structure. They charge 17% administrative charges of
Hmm.
the arbitration fee, in which there are 20 conference room, you can say, not
Hmm.
courtroom. So
Hmm.
where arbitrator comes and sit, suppose somebody is sole arbitrator or some multiple also, or suppose three arbitrators are there. So one can have those rooms. Or you need not to pay, arbitrator need not to pay any fees.
Hmm.
Parties are paid in advance 17% of the arbitration fees as administrative charges. Very fair system, very fair. In which they provide one deputy counsel
Hmm.
who handle the files of the dispute,
Hmm.
and there is a one stenographer assistants who are mostly are the retired or outsourced people, those who assist the arbitrator in drafting and typing.
Okay.
Those are called secretarial assistants.
Hmm.
And another I have already said deputy counsel is there.
Hmm.
And third one is MTS, multitasking staff, who will provide you, like for parties and arbitrator, they serve the tea, coffee, and biscuits and drinking water.
Okay.
So very good system. Instead of going to court or a hotel somewhere,
Hmm.
not required.
Not
So
required.
I prefer to do arbitration in DIAC only.
Hmm.
Court. And it is not the case that you should have their cases only.
Hmm.
Suppose some party comes to you can ask him to apply to DIAC
Hmm.
and deposit the money. So because otherwise arbitrator has to chase those people for paying
Hmm.
fees.
Hmm.
Like in advocacy, if you will come, many clients will come to you,
Hmm.
and unless until you ask them to deposit professional fees with you at least 50%,
Hmm.
they will not turn up. Serious litigant will not turn up.
Hmm.
And at the end of disposal of your case, so suppose your case taken 4 or 5 days,
Hmm.
then he may come one day, he will take away his file, and for fees you have to change through bar council or any other method. So that is also, I must say, hazardous, professional
Yes.
hazards.
That is
Uh,
actually the court revolution that we were talking about.
yes,
Hmm. I
and
agree.
for asking fees, you have to wakalatnama system.
Hmm.
Wakalatnama, always prepare wakalatnama with proper stamping and advocate welfare fund.
Hmm.
Suppose you are going to complete when June or this June or next year,
Next year.
next year.
Hmm.
So you must get prepared. Suppose you undertake the exams.
Hmm.
The moment result comes, you apply for provisional degree or certificate from your institution
Hmm.
and apply for enrollment.
Okay.
Because nowadays there is a system of passing one professional test you have to give.
Hmm.
EIBE, they called it, uh,
Yes.
bar exam,
Yes.
bar eligibility test.
Yes, sir.
So because orders of the Supreme Court and Bar Council of India, they
Hmm.
have made this system. In my time, this was not required.
Okay.
But and 45 is the upper age limit for enrollment
Hmm.
nowadays.
Hmm.
Though this order or rule is under challenge before Supreme Court, so
Hmm.
that's why enrollment is even for more than 45 also.
Hmm.
Normally, Bar Council of India suggested not more than 45 years. They
45.
want young people should come and join. So this is one way. Then in 23, your Mediation Act came.
Hmm.
Mediation Act came,
Hmm.
and under that also there is a mediation council is there where mediator has to enroll and
Yes.
get impaneled uh,
Hmm.
before the authority, that
Hmm.
council.
Hmm.
Right now, I am not aware of these councils have been created at state level.
Hmm.
Uh, One can inquire from Delhi High Court. At least I can inquire for you people if it is there, because normally there was no control over mediator also. So
Okay.
now they have mediator council of that High Court particular,
Hmm.
and one has to apply, and then he get impaneled, for which 40 hours training is required to
Hmm.
becoming a mediator. 40 hours.
Hmm.
So where those trainings are taken out, one under Supreme Court
Hmm.
ages,
Hmm.
and one is under various franchisee, means I can say like Dr. Deepika and one Vinita Sahai. They have
Yes.
also been authorized to
Hmm.
provide certificate of mediator.
Hmm.
There you can join 40 hours. 40 hours is prescribed period.
Hmm.
Have you gone to their Sandhi scheme and other places
Yes,
of
yes.
InADR?
Gone
Yes,
to
sir.
Samvad. Yes, I've been
He is
to
very
Samvad.
proactive. He is very
Yes.
proactive.
Yes.
Acha, what is the difference between mediation and arbitration? Arbitration is a private settlement, just
Hmm.
like
Yes.
arbitrator is there, whether it is a sole arbitrator
Hmm.
or multiple member. Members are normally odd
Hmm.
numbers. Three, one after one, three,
3,
and
5.
5, 7,
Hmm.
9, like that. As number can be appointed. What is the difference? How third this arbitrator is appointed? Every international
By the
arbitration, you will
parties of
find a multiple number.
yes,
Uh,
yes,
Two arbitrators select third one.
that one.
They invite the names from both parties, and
Hmm.
out of that they make the panel,
Hmm.
and they select themselves,
Hmm.
which is called neutral umpire. Neutral. or presiding
Deciding
arbitrator.
for. Yes.
Yes, I am doing like international arbitration. There is a neutral arbitrator is from Singapore
Okay.
side.
Hmm.
Uh, and arbitration seat is also there under Arbitration Act.
Hmm.
So that is based upon your commercial agreement between the parties.
Hmm.
Before entering into any commercial transaction, you you should have a commercial this agreement. Under the agreement, you provide a clause for arbitration.
Application clause.
Normally, it should have negotiation,
Hmm.
then you should have mediation, and then inferior arbitration, like this. What is the difference between negotiation and this mediation?
It's basically
Mediator
negotiation.
is a facilitator. Mediator
Hmm.
does not impose. He does
Yes.
not pass any order. He
Hmm.
just record the mediation proceeding and
Hmm.
submit to appropriate forum for approval. Once
Hmm.
it is approved,
Hmm.
then it is implemented. But what is the drawback? Both parties to this mediation,
Hmm.
either of the parties can back out because it
Yes.
has no legal
That's
enforce,
not binding.
and
It is.
then whole process is vitiated.
Hmm.
Same way in negotiation.
Hmm.
Suppose you have done negotiation
Hmm.
and somebody guided you after, say, I'm just giving example of you,
Yes. Yes.
not you individually.
Hmm.
So thereafter somebody comes and say, oh, what kind of negotiation you have done, you will be at loss.
Hmm.
Then you can back out.
Back out.
No, 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 this negotiation is not
It's
fair.
not fruitful to me or
Same
lucrative.
way under the, but in arbitration, this facility, this provision is not there.
Hmm.
Once arbitrator decide
Hmm.
an award as per section 34, it is final and binding upon
Hmm.
the parties. Parties can only challenge within how
Hmm.
much period of limitation is there in arbitration? Section 34,
Hmm. It is
30 days. 30
sorry,
days.
30 days.
30
Hmm.
days.
Hmm.
Within 30 days, one has to apply.
Hmm.
Otherwise, after expiry of that period, because there is a no power given to higher court to
Hmm.
extend that challenge.
Hmm.
District judges are, district judges are the appellate authority under
Hmm.
Arbitration Conciliation Act. Whether
Hmm.
it is awarded by Supreme Court judge or whether it is awarded by High Court.
Hmm.
See the irony.
Yes, yes,
And
yes.
after district courts, one can go for High Court appeal, writ side.
Hmm.
That's
And
why
it's actually a wisdom
in
to
our country,
participate.
every litigation,
Hmm.
the alternate mechanisms are there. But
Hmm.
process is very lethargy and slow.
Hmm.
If a party has resources, he can harass the victim side by virtue of money.
Right.
Same way, family court, you have seen family
Yes.
court, husband wife disputes or other parents dispute also come to that. What is their problem?
Hmm.
That's why judges have decided, except divorce case,
Hmm.
family court deal with all kind of cases. Divorce cases goes to district judge only.
Hmm.
And in divorce also, district judge have now adopted one because cases are dragged for decades.
Hmm.
One case we have seen in our memory, 40 years old divorce case.
Hmm.
You see, what is the outcome of that?
Hmm.
I know one person who was member of railway board when he
Hmm.
retires, and his wife was also there working.
Hmm.
Both have contested divorce case in 30,000 court,
Hmm.
though they have been superannuated, but
Hmm.
case was not disposed.
Hmm.
Because wife case was, I will not give you divorce.
Hmm.
So it was dragged for more than 30 years.
Hmm.
So ultimately, what kind of life they lead? That's
They,
why I suggested before entering into any matrimony or any contract, because matrimony is a contract. Though you may differ because of Hindu, we called rituals.
hmm.
जन्म जन्म का साथ है. It is not like that. If
Yes.
जन्म जन्म का साथ है तो केस तो होना नहीं चाहिए कोर्ट में फिर. हैं?
Hmm.
Both sides mutually respect each other, no? But
Yes,
it
sir.
never happens in life. Real life, you will find something different because people are greedy.
Hmm.
People chase before money or
Hmm.
other things. They
Hmm.
have so many abuses.
Hmm.
So you must have heard one madam comes to Dr. Deepika chamber, Sarita Salwan.
No, no,
Have you seen?
no, actually, I'm new
Ah,
here.
yes, sir. You someday you can discuss. She will tell you. She has written very
We
good book,
have to wrap up this.
Harmony to Separation.
Hmm.
They invited me to address. I came to your place. Right
Hmm.
now you are in Siri Fort or in Noida?
Three fourths, sir.
Siri Fort.
Hmm.
They have two offices now, no? Sector 63 and your this.
Yes, sir. Two offices.
So, so they chosen topic like you have chosen today.
Hmm.
What was the topic? Harmony to separation.
Oh.
So initially I thought where harmony is there, where it will be separation.
Hmm.
And when separation is there, there will be no harmony.
Hmm.
Basically, he wrote one very good book on divorce, how to
Hmm.
conduct self divorce without having any guilt in the mind of both sides. Very good book. You must read that book. So that will help you in future cases of dealing with matrimony matter. That will guide you, but quite sure. That
Thank you.
book must be lying in your office there, CD Fort. That's why I asked for that.
Yes, sir. I'll
Whenever
read.
you have time, you should read it. Very
Okay.
small book, but quite elaborated.
Okay. I'll go through it,
So,
sir. Thank you
so
so much. We are
huh,
actually quite short of time, so we'll have to wrap this up.
yeah.
Thank you so much, sir, for joining us and for sharing your insights so generously. Your work
Thank you.
highlights how mediation within the judiciary can reshape not only how disputes are resolved, but how justice is experienced. We are truly grateful for your time and for your continued contribution to advancing dispute resolution. Thank you so much, sir. And to our listeners, thank you for tuning to Me-Arcone Queen. We hope today's conversation encouraged reflection on the power of dialogue and collaborative justice. Thank you so much.
वीडियोस बनाने हैं फिल्मोरा है ना।